Welcome to Atlanta Business and Commercial Real Estate Law Podcast.
Welcome back to the Atlanta Business and Commercial Real Estate Law Podcast with attorney Mark Battleson of Battleson Law LLC. Mark brings over 3 decades of experience across business law, commercial real estate, and deal structuring, with a background that includes both legal work and hands-on business roles. I'm Lisa Mosby, and today we're talking about commercial real estate purchase agreements and what investors should pay close attention to before closing on a deal. Mark, this is a detailed one. We're going deep again today.
Sounds good. Looking forward to it.
All right, so let's start with an easy one. How is a commercial real estate purchase agreement different from the contracts people are used to seeing in residential real estate transactions?
Well, they are different, but the concept is the same. So it's just a question of the level of detail and timing, and a lot of contingencies sometimes in commercial deals. So, yeah, and again, it depends on what you're buying as well. You could be buying raw land in a commercial real estate purchase. You could be buying an adaptive reuse of an existing building that you're going to change completely. You could be buying a fully occupied apartment complex or office space, and there's going to be a lot of issues and questions on the leases and the timing and the value of those leases, et cetera. So the commercial deal is different. Primarily, you're buying a piece of fee simple real estate. Fee simple just means that you're taking title to dirt, and then whatever structures are on that dirt, unless they are segregated and separate, kind of a build to suit kind of thing for a commercial space. So the long story short is, when you go to buy a house, you're going to, you typically just have maybe a financing contingency. You may have an inspection due diligence period that's pretty short. And it's usually just, you hire a third-party inspector. They go in there, they tell it what's wrong with the building, the house, and then you bring that back to the seller and say, all right, fix this. And subject to my loan being available in 30 days, I'll close. With a commercial real estate, you've got all the things I just talked about: land, adaptive reuse, environmental issues. I mean, there's environmental with residential, but it's not a typical high-risk situation. And you've got to evaluate every single aspect of this. So it just takes more time. It's usually a bigger ticket item. It's profit motivated, not just buying a place to live. And there's just a heck of a lot more complexity and staging of what kind of out-of-pocket expense you're going to have early. And then as the contract progresses, what are you concerned with? And it gets into financing, quality of earnings from the tenants that are there. That is a significant part of what you're buying. If you're buying an occupied property, if you're going to try to completely change something let's say you take an office building and want to convert it to apartments. Well, okay. A, you got to make sure that the office building is vacant or soon to be vacant. And then B, what all is it going to really cost me to make this conversion and then get it leased up and make sure it's permitted to do this as well as functional to do it. You're going to have the architects, lawyers, zoning, meetings with cities and counties, all these things that are going to take place within this contract period if you're smart. Or you better be getting a steal of a deal if you are going to go in there without all these questions being answered and budgeted. It's not just getting an answer. It's like, okay, I can do this, but what's it going to cost? And you need to be able to say, hey, this is going to actually be financially feasible for me because of all these issues.
And I'm curious, how does the financial structure of a commercial real estate deal affect what a buyer should negotiate in the purchase agreement?
Well, you want time to figure things out. That's number one. People that try to close fast, sellers want you to close fast. And buyers, if you're going to properly adjust your risk and not have a lot of sunk costs when, let's say you find something out day one and decide, my God, I can't do the deal. Well, it's better to find that out then rather than day 60. And so, but with respect to financing, I mean, financial feasibility is the motive for doing this. It's not like you're doing, you're not going at risk for millions of dollars for fun. You're doing it because you want to make millions of dollars plus some amount, some return on that money. And so, there's going to be debt financing and equity financing. And in more complex deals, there might be mezzanine or preferred equity or things like that. But for kind of smaller business or smaller developers and mom and pop kind of investors, usually it's, you've got your equity and you've got your debt. And your debt is a third-party creditor, whether that's hard money lending, which is super risky and high cost, and then, or a bank or another credit, private credit facility. And then there's some, government-backed loan programs where you can buy real estate through SBA lenders, et cetera. And you usually get pretty good terms, high leverage terms on SBA loans, but they're difficult. And a lot of sellers of real estate don't want to screw around and wait for an SBA loan to go through that process.
So our buyer's done their due diligence. We've negotiated the purchase agreement. We have our deal structure in place. What responsibilities should a seller still be obligated to handle after the agreement is signed before closing takes place?
Well, I mean, it just depends on what kind of deliverables there are under that agreement. Usually, when a seller is trying to get to a closing, the due diligence takes place throughout the entire process. Let's be very clear. So it's like if you submit a letter of intent, which is not what you do in residential. In commercial, you're usually submitting a letter of intent first, laying out the business terms, timing of contingencies such as, hey, look, I won't like a smart raw land or adaptive reuse buyer is going to say, hey, look, I'm not going to close on this thing until I have permits, building permits, ready to go. That can take a year. And so you've got a seller who's sitting there with land or something that isn't being used properly. You want to have contingencies that de-risk things for you if you're going to be paying full price. And so the process isn't, it'll be get a letter of intent completed and then move to a purchase agreement, typically within 2 weeks after that. And then that purchase agreement you'd maybe put down some earnest money, deposit, and then you will have 2 to 4 to 6 weeks to review title. The seller usually provides a title commitment from an insurance company and says, hey, here's all the issues that may have with just problems with the real estate that the title company needs to either insure over or exclude from insurance. And then you as the buyer and your lender need to say, I can live with that. And there could be an easement across. An easement is just a right to access somebody else's property. So, a typical one would be, an electrical or sewer easement across property that's been there 50 years, and people, lenders and buyers will typically live with that unless it creates a critical problem for whatever they're intending to do with the land. The process isn't, the due diligence continues to take place, and you're doing all kinds of feasibility work leading all the way up to the closing. And I think you asked about what the seller's responsibilities are. So just getting back to the core of your question rather than my rambling on, the seller, their responsibility is provide good, clean information. They've got the title commitment. They're typically responsible for soliciting a title insurance company to issue a title commitment. And that gets into the encumbrances on the land. And then if you've got leases, that you need to make sure that you're showing good profit and loss history, good books, and show a rent roll, which is a list of all the leases. And there could be 50 to 500 tenants in a multifamily apartment complex. Could be 50 retail tenants, or a list of every single tenant, the rent they're paying, sometimes their credit worthiness, and the term of their lease. And so that way you can say, hey, look, there's an average occupancy, there's an average rent, there's this. And you can then say the quality of those earnings or the revenue coming in off of that are good. And that's a seller's responsibility. They've got that information, and it needs to be clean and accurate, and you want to verify it. So it's, the seller, unless they're taking on kind of some heightened disclosure responsibility, they don't want to, they want to say, hey, look, I'm opening out at the kimono, and here's the property, here's all the financials, here's everything. You figure it out as a buyer. And I'm not taking on responsibility for that. And unless they fraudulently conceal some physical attribute of the property, then typically the seller isn't responsible for you not conducting proper due diligence.
And if the seller's disclosed all of those things, but the other one that comes to mind that I think about and I've seen happen is environmental issues. And how can an environmental issue connected to a property create risks that the buyer may not fully account for early in the deal?
Well, the buyer's lender is probably going to help them account for that, because the buyer's lender is going to actually, there's a lot of safety when you have a lender. People, think of lenders as a nuisance and everything, but hey, they provide capital, but they also have lawyers, and they also have their experience process for checking out property, and because they don't want to take on any kind of risk associated with environmental. So environmental, if it's quote a greenfield property, which means nothing's ever been built on it, is probably pretty low risk, unless there is adjacent risk. Like if you're downstream or downhill from a refinery, or a fuel storage place, or as simple as a gas station, then there may be higher risk because just, gravity will draw that in onto your property. So there's a phase one environmental and a phase two environmental. Phase one is a non-invasive check of the history of a property to see if it is high risk. And the lender will typically require phase one on a standard commercial real estate loan. And if you don't have a lender, then you better decide whether you're going to have these protections or not, and do your own due diligence and check environmental, because no one's going to stop you if you're paying cash. If you're paying cash, you're taking a big risk on title issues and everything else if you don't basically take the lender's role. I've seen it where people, they've got cash, they buy, not something terribly expensive, but they've got cash, and then they find out, oh my God, there's all kinds of title problems or there's environmental problems. If the phase one environmental, which is basically a history of the property, shows that there may be some problem or a potential problem, it doesn't even have to be a problem, just a potential problem, then you might have to have a phase two conducted. And again, typically a greenfield property is not as big of a deal, but if it's an existing property, or God forbid, what's called a brownfield, which means it had a, steel mill on it, on a large commercial property back, 50 years ago, it's probably pretty toxic. And then you're going to maybe have, if you buy the property, you're going to have some responsibility to clean it up. So you don't want to take on that responsibility unless you understand it. You've done testing, and then you've got a budget to deal with it. If it's a large property, you're likely going to have, there may be some government source. There's super funds that help deal with brownfield environmental cleanup and things like that you might be able to tap into. But again, I primarily deal with mom and pop type smaller stuff now. Commercial transactions under 10 million for real estate. And these are typically smaller properties, and they don't have these legacy issues. But if you step into an environmental problem, there may be somebody on the previous chain of title that has some liability too, but you may have some very significant liability even though you didn't create the problem that's there in the first place.
So here's one that's...
Because society wants these problems cleaned up, and they're going to go for anybody that's got their fingerprints on the chain of title.
And if that's you, after the closing, you'll be there and be responsible.
Yeah, you could be screwed. You could end up, you could have the property not be able to be developed because you can't get the necessary permits because you have an environmental cleanup liability.
So that's a big one for the due diligence. Here's another question. Do you ever get any surprises? Like, you've been doing this a long time. You've been in, such a wide range of transactions, from small mom and pops all the way up to big commercial deals. What are those surprises, those biggest problems that commercial real estate deals tend to have as they move closer to the closing. Not all of them, but things that maybe are unexpected to folks that are listening.
Yeah, but no, like every single deal has many surprises, and that's the thing and so that goes back to having contingencies. Like, hey, if you can tie up a property for a year saying, hey, look, I will only close on this if I get a building permit for a 300 unit apartment complex of this configuration, something very specific, and they don't require you to put down any earnest money, and they're just going to let you tie up the property for a year, and then you're going to progress toward that. Okay, well, that's lower risk as a buyer than if you got $1 million of earnest money that you've got 3 weeks to figure out whether you're going to let that earnest money go hard and non-refundable, unless maybe you have a financing contingency on it if you don't get a loan. But you can craft a contract subject to the seller's willingness to do this in a way that de-risks the process for you as much as possible. The problem is you're also hiring lawyers, you're hiring architects, you're expending other resources and time and energy in conducting due diligence and evaluating stuff, evaluating the property toward making an ultimate closing. And so you're going to have things that jump up all the time. And they can be a problem with the title of the property, a problem with an easement, a problem with environmental, a problem with cost. All of a sudden, you get a bid. You get bids from contractors, and they tell you your $10 million project is going to have $11 million of project costs. Certain areas have rock. Georgia has their pockets of granite. Nashville is basically built on a granite slab. And so there's blasting costs if you're going to end up building, depending on what you're building. Oh. There's water runoff costs. You may have some kind of a septic or sewage problem, depending on what kind of property you've got. So all these things come up. And man, I mean, commercial real estate acquisition is way easier than development because you don't have as many variables in play. But development, I mean, you got so much stuff going on, and even acquisition, there is a lot of stuff going on, and basically you just want to know that you don't know everything, and that you're going to try to keep peeling the onion, and then you want the consequence of walking away to be as light as possible. But during the Lehman Brothers crisis, I worked for the largest apartment developer in the country. And, most of the deals we had, we'd wait to close until we got final, permit ready, or shovel ready permits, but we had a couple deals that we had to walk away from when we were just like, we looked at the visibility of it, or maybe the bank that we were going to borrow from went under. We had, loans from, be it Wachovia or otherwise, those banks go under, and then the acquiring bank is under no obligation to, continue to fund or start funding. And all of a sudden, if you've spent $1 million on an earnest money deposit and another $500,000 on architecture and engineering, and you find out that you can't get the financing to do the construction, or just that the costs went up and through the roof, you may have to take the painful pill of walking away from extremely high sunk costs. So it's all about, you're going to have surprises, whatever they might be. And then it's a matter of having contingencies to get you out of things in the event of certain surprises, or just make sure that the pain is as minimal as possible if you decide that you have to walk away for whatever reason. And then that leaves the seller holding the bag, so they're going to try to make it as painful as possible for you, right? So it's a balancing act in negotiating these things.
It really is. And you have to know what your numbers are so that you can follow it through to what your endpoint is, whatever that might be. Thank you so much.
Right. Yeah. If you do not understand the economics of your deal, then you shouldn't even be hiring, or you shouldn't even be submitting a letter of intent. You have to have some level of, it could be back of the envelope math of where you're starting from, but then you better get super detailed, because the lender's going to require it anyway.
And those surprises are the things that you can't plan for, but yet you need to have a slush fund for, and you need to set up your financial structure so that you can cover those things. And oftentimes we forget that. We don't pay attention.
You do not want to get hit with what's called a specific performance claim. If you do not want to close on a deal, and you're under a contract, and you want to make sure that your escape valve is some kind of a liquidated damages that, hey, look, the earnest money is the only thing at risk here. So whatever that amount is, if I decide to walk away, that's the only thing I'm on the hook for. Plus, my out-of-pocket expenses associated with this. That's the extent of my liability. A lot of contracts, purchase agreements, have a specific performance clause to where if the buyer does not perform, the seller can try to force them to perform. Now, usually the specific performance goes buyer forcing the seller to sell, because if you get a good deal on it and then the seller gets a higher offer later, the seller may not want to sell. But there can be reverse specific performance depending on what the nature of the deal is, and when buyers want to walk away, such as COVID. I negotiated a number of deals to where, with developers just on people buying luxury homes and things like that. And then because COVID hit and people panicked, turned out would have been a great time to buy a house. But because, interest rates went through the floor and deals and real estate prices went through the roof for a period of time. But people panicked. And in particular in commercial properties, office has never been the same since COVID. I mean, I'm in a home office right now. I'm not in my office in Midtown Atlanta. And so it's just things change and you need escape valves if you're a buyer. If you're a seller, you want to clamp down on them as much as possible and make it painful for somebody to walk away.
Mark, thank you for always keeping our eyes open and giving us the awareness to look at these deals critically before moving forward. We appreciate your time today.
That's my pleasure.
That's it for today's episode of the Atlanta Business and Commercial Real Estate Law Podcast. If you're buying commercial real estate and want guidance reviewing a purchase agreement before closing, you can visit battlesonlaw.com to connect with Mark. Thank you for listening, and be sure to leave a review, and subscribe to this show. We'll see you next time.
Thanks for watching. Be sure to hit that like and subscribe button and leave us a review in the comments.